Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today's Tuesday at 10 a.m. here Pacific, and welcome to the Bottled Business Sense show. I want to welcome all of our returning viewers, and if you're watching this on replay, welcome again. You know, we have a whole host of free videos out there just kind of giving you an overview of various different topics on legal aspects as well as marketing, and so we want to welcome you all back. If you're new to the show, welcome. We do have a couple of other avenues for you to connect with us. You can also watch us on Facebook, on YouTube, Twitter, and of course, if you like to consume by audio, join us on iTunes, like us, friend us, and subscribe, and you'll have access to all of the audio versions of our live stream. So I want to welcome everyone here today. So on the other side of the screen, you see my partner from the a little further west than where I'm from, Mr. Bill Bernard. Welcome, Bill. Good morning.
Hey, Rick. Good morning. Good morning, everyone. What Rick was saying, you could really have your own little legal library if you download these things. But again, I want to caution you, because I do get calls all the time, that these are general principles of law, and the idea here on these shows, or these really, in essence, lectures that we give, is really to tune you into the general principles of law that may or may not apply to your particular business or estate situation, and then adapt the facts of your own situation by way of hiring or retaining a lawyer to the principle involved. It kind of raises a flag for you, and you say, hey, this may apply to me. I need to hear about this. Now you have the general foundation by listening to one of our lectures, and now you go to an attorney and talk about your specific situation. I don't answer questions on the phone about specific situations unless somebody retains me as an attorney. All I'm going to provide as a service for free is the lecture that makes up this show, so you can get a general idea of what you might need to know about a particular topic. So with that said, today we're going to talk about powers of attorney generally, because I get a lot of questions on this. And basically, powers of attorney is basically a way that you can have somebody act for you, do something for you. And we break it down into the principal or the agent, or the agent is also called an attorney in fact. So the principal would be yourself, because you develop a power of attorney, and then you have an agent in fact, or an attorney in fact, however you want to refer to him or her, who then has the power to act on your behalf. So let's go through some of the general principles that I think are very important here. One, what can you authorize an agent or an attorney in fact to do for you? Well, you can have someone buy or sell things for you. You can have them apply for public benefits such as Medicare, Medicaid, Social Security. You can have someone manage your business, collect your debts, pay your bills, invest your money, cash your checks. And you can also have somebody institute litigation on your behalf as an agent in fact, or an attorney in fact. So for expeditious purposes today, I'm just gonna call this person an agent rather than an agent in fact or an attorney in fact. You'll know that I mean that they all mean the same. You must understand that in a power of attorney, and we're just talking about general principles right now, you must specify what powers you're going to give your agent and when those powers take effect. So what powers are you going to give the agent, and when approximately are those powers going to actually take effect? Powers that absolutely require specific mention, because there is general language, and again, you can get this through an attorney, that would bestow general powers on your agent, but then there are certain powers that have to be specifically enumerated, and I'm going to tell you what those are right now. My point of view, I just, I'm very anal about that stuff. I would just enumerate every specific power, whether they're required to be enumerated or not specifically. I would enumerate every one of them, so there's no mistakes made. There's complete clarity within the four corners of the document. So here are ones that are mandatory to be outlined and set forth. The power to make gifts of your money or other property that you may own. The power to change your community property agreement, should you have one, because remember, California is a community property state. And the power to designate beneficiaries of your insurance policies. If you're going to give those kinds of powers to your agent, you better enumerate it specifically in the power of attorney. Some powers cannot be given to an agent, so don't bother to enumerate them. And that is the power to vote in public elections. No, you can't do that. And the power to make or alter a will or a trust. You can't do that. Okay. So when does a power of attorney take effect, and how long does it last? Well, a power of attorney can be written to take effect immediately upon the signing, or it can take effect at some future date. That's up to you. The future time, if so, may be a specific date, or may be identified by the occurrence of some event. For example, a decision by your doctor that you're unable to make decisions on your own. Once that doctor makes that decision, boom, the power of attorney goes into effect. If that's the specific instance that you outline in the power of attorney that would require it to then take effect. A power of attorney can be written to last either for a limited period of time or an indefinite period of time. That's up to you. However, a power of attorney ends when you die. Why is that? Because remember what I've talked about before. When you do a living trust package, which is what I call it, I don't just do a living trust for you. I do powers of attorney for healthcare, powers of attorney for finance, living wills, declarations, all that kind of thing. A power of attorney is only operable while you're alive. Okay? Once you pass, the probate court takes over your affairs if you don't have a trust. If you do have a trust, then the trustee of that trust, the successor trustee, steps in and runs the affairs of your estate. There is no power of attorney possible in any way, shape, or form once you die. Okay, so let's now talk a little bit about a durable power of attorney. That's a phrase you've all heard all the time, right? Unless your power of attorney specifically says otherwise, your agent's power ends if you become mentally incapacitated. So let's say you just have a general power of attorney. You say it's going to start now. If you become incapacitated, your power of attorney ends, and that agent is powerless unless it is a durable power of attorney. If you have a power of attorney that says that it is to remain in effect if you become disabled or incapacitated, or that it only goes into effect if you become disabled or incapacitated, then that's called a durable power of attorney. Okay? Durable powers of attorney can be written to cover two situations. One, you want to grant the agent to have authority only if you become unable, right? Incapacitated or disabled. Or you want the power of attorney to take effect immediately and to continue should you become disabled or incapacitated. Either one of those two scenarios occur, or in other words, any one of those two scenarios is what you desire as the principal, then your power of attorney is a durable power of attorney. Now, can a durable power of attorney also be used to make healthcare decisions? You need two powers of attorney. You need a power of attorney for financial affairs and a power of attorney for healthcare decisions. And the answer is yes. A durable power of attorney can say, once I become incapacitated or disabled, Joe Blow runs my financial affairs. And then the second power of attorney under the same circumstances says Mary Jones makes my healthcare decisions for me. You can have the same two people make those decisions, but most people often have different people because the person who's responsible and has the astuteness to make financial decisions may not always be the person you want to make your personal healthcare decisions. That's just a natural thing, right? You might have a family member or somebody else that you really trust that you know is aware of your health conditions. Whereas another guy might be really sharp on making financial decisions, and he or she would have no reason to know about your health problems if you have any, right? So let's talk about whether a durable power of attorney is an alternative to guardianship or conservatorship. A durable power of attorney is an alternative to guardianship only if given before you become incapacitated. In other words, if you become disabled or incapacitated, you then can't make a power of attorney if you don't already have one, because you're incapacitated, you're disabled. You can't function. You don't know how to, what your wishes are actually going to be. So in that instance, depending upon the circumstances, which we're not going to get into on this show, you can get a guardianship, or someone can go into court and apply for a conservatorship to run your affairs. That's not cheap to do, but if that's what you're left with, somebody needs to take charge, and that's the way you get a court involved. Once you have lost capacity, again, it's too late to make the power of attorney, and at that point, as I say, the court becomes involved and money starts getting spent. Another good reason to have a power of attorney with a trust in place in case anything happens to you while you're alive. And of course, it covers all the bases after you pass without involving the probate court and the probate nightmare, which is very expensive and very timely, right? And very public. It's not private like a trust. Now, what rules should govern an agent's judgment in making decisions for you? Well, let's talk first a little bit about the agent's liability and your liability if you have a power of attorney and you now have an agent. You ordinarily will be bound by your agent's acts, even if they're foolish acts, and will be responsible for your agent's negligence while the agent is acting for you. So, for example, if an agent is authorized to manage your financial affairs and he or she signs a contract to purchase something on your behalf, you will ordinarily have to pay for it, like it or not. You can't come back and say, well, I didn't want him to do this. You gave him that power, he or she acted, and now you're stuck with whatever he or she did. Rules that govern an agent's judgment. Well, your agent must act in accordance with your wishes as long as you have the mental capacity to make your own decisions. So you need to communicate with your agent so you can avoid what I just described, your agent going out and buying something where you didn't want him to buy it. Now, if you didn't have a problem with your agent buying whatever it is he or she wanted to buy, and they did so, and then you changed your mind, well, as I said before, you're out of luck. You got to stick with whatever decision the agent made. If you lose capacity, your agent should attempt to do what you would have wished if you still had the capacity. That's a judgment call. That's a scenario where you want to make sure you pick the right agent. Okay, it's just like picking a trustee. You want to pick the person you trust to make these decisions for you. Someone who you know has the wherewithal to be able to be objective and who knows you well enough that they're going to be able to make a decision on your behalf based upon their knowledge of you and what they think you would want to happen in a given scenario. An agent who cannot determine what you would have wanted is required to do what he or she believes to be in your best interests. So there's the catch-all, right? But of course, that can always be challenged by somebody. I think it's best to outline a set of principles as to how you want your agent to act. Let the agent have it. So when he or she outlines a power of attorney, becomes your agent in a power of attorney, they have more knowledge than they're coming armed with all the knowledge they need. Again, you combine something like that with a very specific power of attorney, specifically outlining what they can do and what they cannot do. If you want to go that far, that's up to you. And of course, The more particular you are, the less chance of any mistakes being made. How about continuing to act independently after giving somebody a power of attorney? What can you do? Well, giving someone a power of attorney does not prevent you from making decisions or conducting business for yourself. If you and the agent disagree, your position governs, right? This assumes the decisions are announced at the same time. If an agent has decided to sell an item of property and has sold it, again, your later announcement that you do not want to sell it doesn't undo the sale. This is a situation where you both have an eye on a sale, and the agent wants to go sell it, and you say no. Your will controls, right? Makes sense, just common sense. A problem may arise if an agent with a durable power of attorney believes you now lack the mental capacity to act independently or to cancel the power of attorney. In such a case, the agent may file a guardianship proceeding. If he or she now believes that, wait a minute, you don't have the capacity to act on your own. Yeah, you made me your power of attorney, but you can still act on your own if you have the capacity. He or she doesn't believe you have the capacity or even the ability to revoke anymore because you don't have the capacity. Then that person may go into court and again challenge your right to act and rather only leave him or her to be able to act as your agent. So let's talk briefly about whether a power of attorney can be given to more than one agent. The answer is yes. You can give powers of attorney to two or more people at the same time, or you can name a second agent to take over under specified circumstances, such as if the first agent passes away, much like a successor trustee relationship when you devise a living trust. Now, questions that we get all the time, I get all the time, is whether a power of attorney must be notarized or recorded. If you want to give an agent the power to sell land or to transfer or encumber title to land in any way, okay, let me repeat that. If you want to give the agent the power to sell land or to transfer or encumber title to land that you own, the power of attorney must be signed in front of a notary who must note that you signed it voluntarily for the purposes mentioned in it. The power of attorney must also have the following language in bold print at the top of the first page. I'm going to read this, but perhaps Rick can post it if you're really interested, or you can email him. The bold print must say this: if you're going to allow this agent to sell or encumber property that you own. Quote, this power of attorney authorizes the person named below as my attorney in fact to do one or more of the following, to sell, lease, grant, encumber, release, or otherwise convey any interest in my real property and to execute deeds and all other instruments on my behalf, unless this power of attorney is otherwise limited herein to a specific piece of real property. So get that, unquote. You can have him do what he needs to do regarding any property you own. You need that paragraph in there, but you also need that paragraph in there if you want to limit the agent to property A. You may have property A, B, C, and D, but you only want to give him the ability to sell, encumber, lease, whatever, property A, but not B, C, D, and E. So either way, that has to be in here. If you're using the power of attorney for a real estate transaction, it must be recorded in the county recorder's office before or at the same time that the property deed is being recorded. That is the same time the property is bought or sold. A copy of the power of attorney usually will suffice because you don't want to give away the original. Some institutions or individuals may doubt the validity of a power of attorney that has been not notarized. So even if you don't involve selling or encumbering real property or a title of property that you own, you may want to get it notarized, because if you take it to a bank or an insurance company or some other financial institution that requires its presentation to show that you can act on behalf of the principal, they may, they're not supposed to, but they may say, wait a minute, this isn't notarized. I can't authorize it as being genuine. You can fight that, or you can just simply have had it notarized in the beginning. You're not always going to run into that problem, but every once in a while you run into somebody who does that. My position is I take it to another institution of the same nature who doesn't hassle me like that. On the other hand, you talk to your client, your client's wishes control. If you think it's best to have it notarized, what the heck? It's what a $10 signature, I believe, in for Notary Public. Okay, finally, let's talk about whether a power of attorney can be canceled and whether there's any kind of court supervision involved in a power of attorney. To revoke a power of attorney, you should have a signed written notice delivered to the agent and to anyone else that you may know of who is relying on that power of attorney, who you know has communicated with the agent or with you, whereupon you've advised, this is my agent, he's in my power of attorney. So you want to give written notice certainly to the agent and to anyone else that you know of who's relying upon that agent. That's extremely important. If the power of attorney has been recorded for the purpose of allowing an agent to buy or sell real estate, as we just spoke about, you should also record the signed written notice revoking the power of attorney in the county recorder's office where you recorded the power of attorney to begin with. Okay? The notice should include the instrument number and the date of the original recorded power of attorney. Okay? Very important. And finally, ordinarily, an agent with a power of attorney acts without any court supervision. However, a court can be asked to consider certain issues relating to a power of attorney. We touched upon that briefly a minute ago, where the agent is doubting your ability because of a potential incapacity or you're disabled in some way. A court may decide whether a third person must honor a power of attorney if there's a dispute, and it may order an agent to give an accounting to you or to a third party relying upon a business transaction to interpret or modify the power of attorney or even remove an agent. So you may need an accounting, a financial accounting done. You may need the power of attorney modified because of something there's a disagreement in some instance about what the power of attorney controls or says, or you may have a dispute where you have to remove your agent, and your agent wants to continue to act as your power of attorney, even though you may have given him written notice to the contrary. That's why written notice is important. You bring it into the court proceeding, and you do it. You work it accordingly, according to what the court needs to see, and that's very important proof. Bottom line is, you need an attorney to do this. You don't do this on your own. I know there's DIY stuff out there that you can try to take advantage of, but I'll be very candid with you. You're very foolish if you do that. And you're gonna have an instance down the road where it may backfire on you, and you're gonna wish you spent the money to invest having a lawyer prepare it according to the state that you reside in. Okay, so that's kind of the synopsis of a power of attorney. I think it's a very good one. I think it provides you with a sound basis. All you have to do is listen to this recording, and I think you got a real good outline as to what a power of attorney is all about. In every way, shape, or form, you need a power of attorney. Go to your lawyer. Now you can talk intelligently with him or her about what you may have in mind. Okay, so that should do it, Rick. I hope that's helpful to everybody.
Yeah, thank you, Bill. That's, as always, great information for our audience out there. You mentioned estate planning too in part of your lecture today. Tell us a little bit about some of the resources that you have there.
Well, we have a lot of resources. I think if you go to protectyourestate365.com or PYE365.com, which of course stands for Protect Your Estate 365, either one of those URLs will take you to a website where you have videos explaining in pretty coherent detail the nature and wherewithal about an estate plan and what you need to have included. It also has a drop-down box section where you can go to certain questions and read instead of watch videos about certain areas that you're interested in. But what you really need to understand is it's a very economical plan that is geared toward the family. It's the same estate plan that I have for my family. And I'll be very candid with you, that's its biggest selling point. I'm not going to sell something or recommend something more to the point, if I don't believe in it, and I believe in it because it's my own family's plan. Anyway, enough said on that. There are a lot of things that you should think about when you have an estate plan. Think about an estate plan with regard to your family. How about your business? Do you have an LLC or an S corporation that needs to be addressed in your estate plan? Do you have some employment issues that you might need to address in your business? Employment law, estate planning, and of course, the preparation of business entities is what I believe is the three-pronged approach to being a business lawyer. And you need to really keep these shows in mind, because I think we try to touch upon those three areas within the business framework as a whole. So please go and listen to us. I'm going to try to get a podcast going by some of the recordings that we have. Try to transfer them to other platforms so they can just be listened to, because I know a lot of people just like to listen to our shows as opposed to watch them. That's why we're on iTunes. But I want to explore some other areas as well. So please go to the website and check it out. If you have an interest, please understand we have wfblegalconsulting.com, which is the legal website describing all the areas of law that I practice in, the three areas I mentioned: employment law, estate planning, and business entity preparation. The PYE 365, Protect Your Estate 365, is geared specifically toward estate planning, and has pricing on there that you can review as well. So hopefully that helps everybody, Rick. And remember, we're here to give this free information, to give back to the community, to try to help you get an idea of what is or is not of interest to you or of importance to you. And then we urge you to then go see a lawyer to finalize whatever it is you want to have accomplished. Okay.
Thank you, Bill. Make sure to go check out pye365.com. It's extremely resourceful if you're looking for that type of information. And remember, you can always find us on iTunes, Facebook, Twitter, Instagram, and YouTube. And now we've expanded the audio versions not only to iTunes, but you can find us on Spotify as well as Google Podcasts.
There you go. See, he's ahead of me. He knows what's happening here. Also, be aware, guys, that we don't have a regular programming schedule anymore. We try to go for twice a month. Sometimes it's only once a month. Sometimes it may even be 3 times a month, although that's unlikely at this point. So just keep aware of the platforms that Rick just mentioned, because we do advertise as to when the next show is going to be. And if worse comes to worse, you either go to bottlebusinesssenseshow.com or to YouTube, our YouTube channel, Bottle Business Sense. Is it Bottle Business Sense or Bottle Business Sense Show? Is the YouTube channel? It's Bottle Business Sense Show, right, Rick?
Bottle Business Sense Show, yeah.
Yeah. And then you can go, Bottle Business Sense is a newsletter that I had a while back, but Bottle Business Sense Show, YouTube, you go there and you can see all the videos and watch them at your leisure, or go to the other platforms Rick mentioned and listen to them at your pleasure while you're driving or whatever else you're working out, whatever else you may be doing. Okay?
Hey, I was just looking at some of our resources. You realize that we're coming up to the end of our 6th year broadcasting the Bottle Business Sense Show.
I didn't realize that. See, I need Rick to remind me of that. 6 years. Yeah, I remember when we first thought about this. I'm also thinking about, this has nothing to do with our show, but I'm thinking about doing a podcast with my son, who's just an astute sportscaster. And he and I both love sports, and so we're thinking about doing that. So you may see my face roaming around with Rick's help somewhere else. But we enjoyed doing this. This, we're not getting rich off of this. And we do it, as I said, to try to help people kind of get a gauge on how to do things that they may have been thinking about for a while and just have been putting off. Mm-hmm. So take advantage of it, folks, please, and do it in safety and in good health from the confines of your home. Go visit with a lawyer now that things are loosening up a little bit with COVID. And then, get done what you need to while you're still here. So anyway, good luck and be safe out there, and we'll see you on the next show.
All right. Thanks, everyone.
Take care.